Hi, everyone. I'm Alex Klass. Thanks for inviting me to participate in your program today. I'm a professor at the University of Minnesota Law School, and I teach and write in the areas of environmental law, energy law, public lands, and natural resources law. And my remarks today are an effort to explore the relationship between state environmental rights statutes and the common law public trust doctrine in the context of the White Bear Lake litigation that's pending in Minnesota courts. And my remarks today are based on a paper that I wrote in 2015 for a symposium at the Lewis and Clark Law School that was commemorating the work of Joseph Sachs soon after his death. And for those of you who aren't familiar with him, Sachs was a law professor first at the University of Michigan and later at the University of California at Berkeley. And he's really the founder of the modern public trust doctrine, and as a result of a very influential law review article that he wrote in 1969. So, and there were copies of the paper that I just referenced that I think were on the table. They may not be there anymore, but it's free and available on the internet, and that's the title of it up there. Yeah. So the public trust doctrine is an ancient Roman doctrine that was then adopted in England and from England came here, which provides that states, or sovereigns back in the day, hold certain natural resources, particularly submerged lands under tidal and navigable waters, in trust for its citizens and for future generations. So the public trust doctrine is actually kind of a hot topic these days. There's a case going to trial in federal court in Oregon against the federal government for failing to protect children, represented by the group Our Children's Trust, from the impacts of climate change, with the idea that the atmosphere is a public trust resource. And some of you may have seen there was a 60 Minutes episode about the litigation just about 10 days ago. The Pennsylvania Supreme Court has used its constitutional provisions that codified the public trust doctrine back in the 1970s to strike down state laws that were preventing local governments from regulating fracking. This has just happened in the last couple of years. And of course, the public trust doctrine has played a central role, really for the first time in environmental litigation in Minnesota, in the White Bear Lake case, which some of you may have personal involvement in, or at least you've read about in the newspapers. So I want to start here with some history. So around the time that Joseph Sachs was writing his famous law review article on the public trust doctrine in 1969, the environmental movement was getting into full swing in the early 1970s. We had Earth Day, we had the creation of the U.S. Environmental Protection Agency. Many states got into the act as well, and they responded with constitutional amendments, creating rights to a clean and healthy environment. And they also enacted statutes. The legislatures acted to reflect these new ideas about public trust principles. So with regard to these statutes, Joe Sachs actually worked with the Michigan legislature to pass the first one, and several states followed suit. And these laws generally provide state citizens with the right to protect and preserve the state's air and water and other natural resources. And many of these laws also provide a private right of action by citizens against the government or private parties to enforce those rights. But most state courts ultimately didn't find that those statutes provided any real legal rights beyond more general environmental standards that were enacted around the same time. Even in Michigan, kind of the home of the signature law of this type, the courts ultimately placed quite a lot of limits on the ability of citizens to bring lawsuits under the statute. Minnesota, though, is a different story. So the Minnesota Environmental Rights Act was modeled after the Michigan law. It's known as MIRA. And Minnesota courts very early on interpreted it to provide broad citizen standing to sue governments and private parties to protect a wide range of natural resources from pollution, impairment, or destruction. Many of these cases were decided in the early 1970s and up until the early 1980s. Now, during this time period, this is when states like California and Louisiana and Hawaii and others were expanding their common law public trust doctrine, judge-made law, to protect natural resources because they didn't have a nifty new statute to protect those resources. So during this time, we had states developing their common law public trust doctrine, and Minnesota had MIRA. So during this time, Minnesota courts decided almost no common law public trust doctrine cases that involved natural resource protection. All that litigation was channeled through MIRA. And this is really noticeable because Minnesota was a real leader at this time in creating new environmental agencies, new progressive legislation and regulation to protect the environment. But the courts did nothing with the public trust doctrine because it didn't have to. All the lawyers were bringing cases under MIRA. Why would you use an old fuzzy common law doctrine if you had a new statute that was much clearer? So the question for the paper that I wrote was whether this focus on MIRA in the early days somehow stunted the growth of the common law public trust doctrine here in Minnesota, and whether that's a problem. Don't we want to rely more heavily on statutes rather than the common law when we can? So the White Bear Lake case is the first case that I'm aware of to raise both a MIRA claim and a common law public trust claim. And so it kind of provided the opportunity to reflect on these questions. So that's a very long introduction. So what I want to do now is tell you first a little bit more about the public trust doctrine in MIRA. Then I'll talk about the White Bear Lake case. And that, as many of you know, went to a 3-week trial in Ramsey County District Court in the summer of 2017. It's now on appeal to the Minnesota Court of Appeals. After talking about the White Bear Lake case, I'll speak a little bit more about some concerns, these concerns that I have, about allowing the common law public trust doctrine to lie dormant in favor of a statutory environmental protection vehicle. Okay, so what's the public trust doctrine? So the idea of the public trust doctrine is that the state holds submerged land under tidal and navigable waters in trust for citizens and for future generations. So, as I said, this started in Roman law, then English law, didn't get to the U.S. Supreme Court until the Illinois Central Railroad versus Illinois case in the 1890s. So, back in the 1890s, the Illinois legislature decided it would be a fabulous idea to sell the entire Chicago harbor in Lake Michigan to the railroad. And they did that and entered into a contract with the railroad. Then a new legislature came in the next year and thought, maybe this was not such a good idea. And they rescinded the contract. Of course, the railroad sued. And the question that went up to the U.S. Supreme Court was, did the Illinois legislature have the authority to sell the Chicago harbor in the first place? If they didn't, then there's no breach of contract because they didn't have the authority to enter into the contract. The Supreme Court said that the legislature did not have the authority to sell the submerged lands under Lake Michigan. The idea is these are public trust resources, and the state has an obligation to protect them and preserve them in trust for state citizens and for future generations. And typically what they were talking about at that time was not environmental protection, but it was fishing, it was navigation, recreation as well. So we have that case in the 1890s, and then nothing really happens for a long time. And then Joe Sachs comes along, and he is an expert in water law and environmental protection, and he sort of dusts off this old public trust doctrine and says, this would be a great way to allow citizens, private citizens, to sort of force their regulators, who maybe are not acting to protect the environment, to do that they have an obligation beyond what the legislature might say to protect resources. And, a lot of law review articles get written. I write 1 or 2 every year, and, they sit on a shelf, and no one really looks at them. Well, this one really took off. All of a sudden, people are talking about this. Legislatures are acting. Obviously, 1969 comes along at a very good time. So, as I mentioned before, he worked with the Michigan legislature, and other states around the country began to sort of codify this idea. So, put in legislation this right that states had to protect natural resources. So that's happening in the 1960s. The first very famous case to actually implement this doctrine is what's called the Mono Lake case out in California. So anyone been to Mono Lake? Beautiful, isn't it? Fairly near Yosemite National Park. They are not the land of 10,000 lakes there. It is the second largest lake in California. And there's non-navigable streams, freshwater streams that feed the lake. Now, Los Angeles, as you know from the movie Chinatown and all sorts of other things, is always hungry for more water as they develop. So LA received permits from the State Water Agency to basically appropriate all the water in those streams. And the water diversions began, the lakes began to dry up, migratory birds could no longer go there, and the plaintiffs, environmental groups, sued. They sued the state and said this lake was protected by the public trust doctrine. And the state's argument is we have a water code. Domestic use of water is the highest use in the water code. We have no choice. We would like to protect the lake, but we have to grant the permits. Court disagreed. The court said there's an obligation by the public trust doctrine and there's an obligation in the water code, and you, the agency, have to balance those two. You can't pick one over the other. So I have a quote up here that talks about that both the public trust doctrine and the water rights system embody important precepts, and you can't embrace one system without the other. Go back, try to balance it, which over the years the regulators in California have done, and we can still enjoy Mono Lake today. So as I said, other states, California is really a leader in interpreting its public trust doctrine in a way to protect the environment, but many, many other states have similar cases, particularly when it comes to waters and submerged lands under navigable waters. But the Minnesota legislature sort of took a different tack. They really embraced this idea of a statutory vehicle and enacted MIRA. And if you look at the language, it's a pretty broad and pretty strong purpose. The legislature finds and declares that each person is entitled by right to the preservation and enhancement of air, water, land, and other natural resources located within the state. Each person has the responsibility to contribute to the protection, preservation, and enhancement thereof. It's the policy to create and maintain within the state conditions under which human beings and nature can exist in productive harmony in order that present and future generations may enjoy clean air and water, productive land, and other natural resources with which the state has been endowed. It is in the public interest to provide an adequate civil remedy, so the ability to bring a lawsuit, to protect air, water, land, and other natural resources located within the state from pollution, impairment, and destruction. And the statute goes on to make it clear that anyone may maintain a civil action in a state district court for declaratory relief and injunctive relief, not for damages, but for a declaration and a declaration that there is to protect the air, water, land, or natural resources, and an injunction to stop behavior that would threaten that. And it doesn't matter whether these are resources owned by the state or owned by a private party. So what's a natural resource? It's not just submerged lands under navigable water. All mineral, animal, botanical, air, water, land, timber, soil, quietude, recreational, and historical resources, as well as scenic and aesthetic resources when they're owned by the government. So a very, very broad definition of natural resources. What's in pollution, impairment, or destruction? Well, anything that violates an environmental quality standard, limitation, rule, order, or license, so something that the legislature or a state agency has said you can't do. But also, number two is very important. So even if there isn't a permit that's being violated, even if there isn't a law or regulation that's being violated, if the plaintiff can prove that the activity will materially adversely affect or is likely to materially adversely affect the environment, that is also a violation of MIRA. What's a material adverse effect? The courts had to figure that out pretty quickly because many quite small things would seem to fall under this. And so the court came up with several factors. They actually borrowed it from a Michigan Supreme Court case that had a similar statute. And it's looked at how rare, unique, or endangered are these resources? What are the long-term effects? Are there effects on other natural resources? Are these natural resources we have a lot of or a little of? To try to sort of have a materiality standard. So Minnesota courts have for quite a long time used MIRA fairly frequently to protect a wide range of resources. So I list some here. These are all cases that have been decided by the court. So MIRA has been used to protect birds, trees, wetlands, quietude, marshes, and lots of projects from highways to jails to a radio tower to tree harvesting have been enjoined or stopped as a result of the law. So some of you may be familiar with this case. It's a very famous MIRA case from the 1970s. Mr. Bryson had a farm, and there was a wetland on the farm, and the county wanted to fill in the wetland for a highway. And he said, no, I like my wetland. I don't want you to fill it in. And of course, the county said, well, we have eminent domain authority. We can build the highway if we want. So we brought a lawsuit under the Minnesota Environmental Rights Act, and actually the state of Minnesota intervened on Mr. Bryson's behalf, so they were both plaintiffs in the case. Case went up to the Minnesota Supreme Court, and the language in the decision, I just have a bit of it excerpted here, is really quite beautiful. Times change. Until MIRA was passed, the holder of the power of eminent domain had in its hands almost a legislative fiat to construct a highway wherever it wished. However, the consequence of such construction has been the elimination or impairment of natural resources. Whether for highways or for numerous other reasons, including agriculture, it is a well-known fact that marshes have been drained almost indiscriminately over the past 50 years, greatly reducing their numbers. The remaining resources will not be destroyed so indiscriminately because the law has been drastically changed by the act being MIRA. Since the legislature has determined this change is necessary, it is the duty of the courts to support the legislative goal of protecting our environmental resources. And then the court goes on to talk about what a swamp is, what a marshland is. That even though we used to try to fill them all the time, they were just trouble, we now realize that a swamp or a marsh is a thing of beauty. To one who is willing to risk wet feet to walk through it, a marsh frequently contains a springy soft moss, vegetation of many varieties, and wildlife not normally seen on higher ground. It is quiet and peaceful, the most ancient of cathedrals, antedating the oldest of man-made structures. More than that, it acts as nature's sponge, holding heavy moisture to prevent flooding during heavy rainfalls, and the court goes on from there. Not bad from the Minnesota Supreme Court, right? The court also goes on in the opinion to quote Aldo Leopold's Sand County Almanac, and it's really a very lyrical opinion. Okay, so we have lots of MIRA cases from the court since about 1971. No public trust doctrine cases at all, except two. One, someone tried to prevent the DNR from selling land, not water, that was part of a state wildlife area, and the court, not surprisingly, said, no, the public trust doctrine is about submerged lands. It's about water. It's not about other types of land, which was consistent with the case law at the time. And then there was also a lawsuit brought in Minnesota by the group Our Children's Trust to try to force the Minnesota Pollution Control Agency to set carbon limits, so one of the many lawsuits that they filed. And they actually asked me if I would be the local counsel in that case. And I said, a public trust doctrine claim? There's no decent public trust doctrine case law in Minnesota. You could try a MIRA lawsuit, that would be good, but it's not a very good claim here because we don't have any helpful case law. And not surprisingly, both the district court and the Court of Appeals said, no, there's no case law in Minnesota to support the public trust doctrine protecting the atmosphere. There's some older public trust doctrine cases, but they aren't about environmental protection. They're more about a lake drains, who owns what was before submerged land? Is it the state or is it a private party? So again, not for environmental protection purposes. And again, I'm not faulting lawyers for not bringing public trust doctrine cases because you've got MIRA. So all this litigation gets channeled through MIRA. Okay, that brings us to White Bear Lake. Many of you are familiar with White Bear Lake. Here are some photos. So from 2003 until about 2011, we had average precipitation in the area, but the water levels in White Bear Lake dropped as much as 5 feet, so lowest recorded levels. I have some friends who live on White Bear Lake. It's really interesting to see the lake levels go up and down. They're quite high now, but you may know that they were very low during this time period. And the U.S. Geological Service found that the decline in lake levels was due to increased groundwater pumping from growing municipalities in the area. That's an area of pretty high growth. These are cities that are not hooked up to the regional water system. Minneapolis and St. Paul, of course, get their water from the Mississippi River, but all of these other towns, and actually a big chunk of Minnesota, get their water from high-capacity groundwater wells. The DNR is not in the habit of denying permits because we've always had enough water. We're the land of 10,000 lakes. So this became a problem. So a group of homeowners in the area and a group of businesses brought this lawsuit, and they brought claims under both the Minnesota Environmental Rights Act and the Public Trust Doctrine. So this case has been going on for a while. There was an effort by the defendants to get the case dismissed. They moved for summary judgment. And in 2014, the court said, no, I think that the lake bed and the lake are public trust assets. They are protected by the Public Trust Doctrine. Is there a violation of the Public Trust Doctrine? Well, we need more facts. We have to have a trial, which I think was the right decision. Also, question of, did the state violate the Minnesota Environmental Rights Act? It applies, but you got to prove that there's a violation, that there's a material adverse effect. So again, the court said we can't decide this just on paper motions. We have to have a trial. We have to have testimony. We have to take evidence. So 2017, they had a 3-week trial, lots of witnesses, lots of testimony, and the order that the Ramsey County Court issued, 140 pages, found a violation of both the Public Trust Doctrine and MIRA. And in the order, prohibited the DNR from issuing additional groundwater permits until the state had done a cumulative analysis of the impact of existing wells, set a minimum elevation for the lake, and said when the water fell below that lake elevation, there would be some irrigation bans in the area, and also said work on shifting these cities to the regional water system, which obviously would need a legislative authorization and a lot of money. So those of you who have lived in the West know sometimes there's irrigation bans, sometimes there's limits on water. We are not used to that here in the state of Minnesota. So this is seen as fairly radical, right? So the legislature in 2018 enacted a law to prohibit the DNR from implementing some of these provisions, which raises a really kind of interesting separation of powers question. Because where does the Public Trust Doctrine come from? Is it part of the US Constitution? Is it part of the Minnesota Constitution? Can the legislature just get rid of it when it wants to? There have been a few cases that touch on this issue. Illinois Central obviously would seem to say the legislature can't, because recall, it was the legislature that tried to sell the Chicago Harbor. There's a couple cases from other states where the legislature tried to restrict which types of water bodies were subject to the Public Trust Doctrine, and the court said they couldn't. So you could argue it's the court, not the legislature, who actually has the final say on the Public Trust Doctrine. The idea that even though we call it the common law Public Trust Doctrine, it's actually almost constitutional or a super statute. Normally, with common law, the legislature can override it if they want to. This may be a little different. This has not yet been addressed by the Minnesota courts. The defendants, the DNR, said we want a stay of the district court judgment while we appeal this. The district court said no, it gets implemented right now. That decision went up to the Minnesota Court of Appeals, and the Minnesota Court of Appeals said, why don't you look at it again, district court judge, and see what, since the legislature has passed this law, whether you really think there shouldn't be a stay. And so last September, the district court said, okay, for the issues addressed by the legislation, the stay is only until 2019, with the idea that the court will decide, the higher court will decide the issue by then. They said, okay, I will grant a stay as to the issues that were addressed by the legislation, but other things like doing a cumulative assessment, doing the things the DNR was ordered to do, that goes forward. The Court of Appeals just heard oral argument in the case in January, and interestingly, the questions from the court were all about the MIRA claims, and there was actually nothing about the Public Trust Doctrine claims. Doesn't mean they won't decide the issue, but they seem to have less questions with regard to that. So we will see what happens with it. So you may be thinking, well, what's the difference? If you have MIRA, why do you need the Public Trust Doctrine? And so here on this slide, I kind of put together what I think some of the benefits and the limits of each avenue are. So the benefits of MIRA is they cover a broad range of resources. You saw the definition of natural resources, and it is way beyond submerged lands and water, right? You also have pretty clear standards. For plaintiffs, you have strong case law, so there's just more to work with. There's limits of MIRA. I always joke with my students that if MIRA were used more often than it is right now, the legislature would immediately repeal it. And of course, the legislature can amend or repeal MIRA whenever it wants. We've been talking a little bit just in the last hour or so that I've been here about farming operations, and of course farming operations were specifically excluded from MIRA. So in Minnesota, like many other farm states, there's kind of a sense of agricultural exceptionalism. The law applies to everyone except agricultural operations. So really you can't use MIRA if you've got farming operations, whether small or large, that are impacting natural resources. Public trust doctrine. So what are some of the benefits? Certainly flexibility, right? Because it is vague, you can perhaps develop the common law in a way to use it for different purposes. It's being used in a different way now across the country than it was used back in the time of Illinois Central. You can't really repeal it, at least we don't think you can repeal it. There's no exception for agricultural pollution, although there's been really a dearth of public trust doctrine cases involving large agriculture, which I just think is interesting, something for future thought. The other thing that happens with the public trust doctrine is state agencies can use it defensively. So when the state, the DNR, is trying to protect a water body, or a natural resource, oftentimes there's a private property owner involved who says, you are regulating in a way that is taking my property. This is a regulatory taking and you have to pay the value of the land. And there are lots of instances where states have successfully argued, no, we have to regulate this because we're obligated by the public trust doctrine. So it's something that state DNRs and pollution control agencies can use defensively to avoid takings claims, and that has been used successfully in a range of states, which is why in some ways I was a little disappointed in the DNR's efforts to interpret the scope of the public trust doctrine in this case very narrowly, because in terms of short-term litigation strategy, that was a good strategy. But in terms of long-term DNR authority to be able to use the public trust doctrine in the future where they may want to protect a lake or a resource, might end up with some bad case law. There are, of course, limits of the public trust doctrine as well. In Minnesota, we just don't have a lot of case law on it, so it's a risky theory to bring if you're a plaintiff because there's not a lot of cases you can cite to the court. That we'll see whether this case results in helpful case law or harmful case law when the Court of Appeals and probably the Minnesota Supreme Court rule on the issue. And historically, it has been limited to submerged lands and waters. California has extended it beyond that. We will see if what happens with the Children's Trust case, whether it will be extended to the atmosphere. That's a big extension. But typically it works for White Bear Lake because White Bear Lake is a traditional public trust resource. It's a large lake, right? So under any interpretation of the public trust doctrine, it is protected. So with that, here's some sites to some further reading. I mentioned the first article already. That's the one that was here before, and then a couple of other things that I've written on the public trust doctrine. So with that, I'd love to answer questions you have on MIRA, on the public trust doctrine, on the White Bear Lake case. So the question is potentially could MIRA apply to the proposed mining up in and around the boundary water, so the Polymet mine and Twin Metals as well. I mean, in both cases, the big concern, of course, is impact on water resources. And so even though the mine itself wouldn't be a public trust resource, what you would argue is that those activities are having an impact on a protected resource. And so, yes, in theory, it could apply both the public trust doctrine and, of course, MIRA. You don't even need to make that stretch because it's just a much broader statute. Other questions?
Yes. One, and maybe I was concentrating on something else. I didn't hear all of what you said. But Ohio recently recognized that Lake Erie has the status of a person?
Yes. I think a court in Ohio, well, no, they did a referendum, I think, right? I think there was a citizen referendum to have Lake Erie have status to be able to sue, just like a corporation can sue, right? So what happens with that referendum and how the courts see that, I'm not sure. What I thought you were going to say, though, is Indiana, the Indiana Supreme Court, just a month or two ago, used the public trust doctrine to very broadly protect public access to all of the beaches around Lake Michigan and Indiana. So another use of the public trust doctrine that we haven't talked about today is for public beach access. So as you may know, some states, all beaches are public, some states they're not. A lot of that is based on how their courts have interpreted the public trust doctrine. So New Jersey interprets the public trust doctrine to provide very broad beach access, and now Indiana actually has the broadest public trust protection of beaches, I think, of any state in the Midwest, which was sort of unexpected.
Willis Matson, I would announce that the White Earth Tribe just granted wild rice the same right of personhood. So it'd be interesting to see who challenges that. Then also, you might be interested in coming over to the Environmental Quality Board meeting on April 14th when the founders of Minnesota's MIRA and MIPA Act will be presenting the intent and theory and practice of MIRA in the state.
Yes, Chuck Dayton told me that he was going over to do that.
Yes. Then finally, you raised an interesting question that I think applies to pipelines. There are many private landowners who are resisting the imposition of the eminent domain on their property. Does this actually open private property owners' possibility to claim that the public trust resources that abide within the property they have control over are entrusted to them and cannot be taken even by this eminent domain power that is granted to pipelines?
That's a tough one. I mean, you can make that argument. There's not a lot of good case law in Minnesota. And the other thing I should say, this is true in response to the question about the mining as well, is one other limitation of MIRA is that if you have a state permit to do what you're doing, oftentimes you can't bring a MIRA lawsuit. So you kind of have a permit shield. Would not apply for the public trust doctrine, right? The whole idea is the state is allowing you to do something that the state has an obligation to protect you against. So there you could maybe use a public trust doctrine claim. It's just the problem with a common law doctrine is you need to rely on case law in the state as your law. And that's the issue in Minnesota is we don't have any law on it. We will have some law on it when the know yet whether it will be helpful law with regard to plaintiffs or harmful law, right? So it could be interpreted very narrowly.
You mentioned that the permit provides a shield, but then that early case you talked about at the beginning, the legislature sold that harbor, but then that got reversed, and that was something the state did.
Right, but the Illinois case was a public trust doctrine case, and the Bryson case was a MIRA case, right? So having a permit is a defense in a MIRA lawsuit. It's not a defense in a public trust doctrine lawsuit. So you could bring the public trust case, but you might not be able to bring the MIRA case.
Okay, and then did you say something about Minnesota Children's Trust on Climate Change or Oregon or
yes.
What was that?
So there's a national group. It's called our Children's Trust, and the strategy was, this was several years ago, is basically the idea is the climate change is going to have the biggest impact on future generations, and part of what the public trust doctrine is supposed to protect is future generations, right? So what they did is they filed a lawsuit on the same day in every state and against the federal government under the public trust doctrine to say that each of these states and the federal government has an obligation under the public trust doctrine to, reduce the levels of CO2 in the atmosphere to protect future generations. And the idea is the atmosphere as a whole is a public trust resource, just like a lake would be. almost all of these suits have been dismissed, and most of the courts have said the atmosphere is not a public trust resource. We don't have any case law that says it's a public trust resource. This old Roman doctrine was based on water resources, and based on the case law, that's accurate. But of course, the common law can change. The 14th Amendment, Equal Protection Clause of the U.S. Constitution, didn't say that it was required that black students and white students have the opportunity to go to school together until Brown versus Board of Education. That was really radical at the time, right? It was a change in the law, and now it's just what the law is. So the hope by the plaintiffs is that the public trust doctrine will move in that direction as well. So there's one case that has succeeded so far. It was filed in federal district court in Oregon, and the federal trial court judge found that the federal government had public trust obligations, that the atmosphere was a public trust resource, and that the federal government had to act. They also found a due process violation and equal protection violation, equal protection between young people and future generations and others. That's on appeal right now. It's been about to go to trial for several months. Obviously, the federal government does not want this case to go to trial, and so there have been efforts to get the U.S. Supreme Court to shut it down, the Ninth Circuit to shut it down. We will see. So when it was the Obama administration, all of the oil and gas companies also intervened in the lawsuit as defendants, as additional defendants, because of course they didn't trust the Obama administration to properly defend the lawsuit. Once President Trump was elected, all the industry dropped out because they had more faith on the defense side, and also because if they're in the lawsuit, then discovery, document requests, depositions will happen against them, and they didn't want to risk that. So it's a fascinating case, and I do suggest you watch the 60 Minutes episode. You can get it on YouTube to get a sense of kind of what's going on in the case, and you can find a lot online as well. She did.
Oh, she did dismiss them.
Oh yeah. Yeah, they were voluntary. They were voluntary parties. Yeah.
Once you're in, you're in.
Well, I think they still have to file briefs, but yeah, they're not subject to discovery.
The Clean Air Act, wouldn't that say that the air is a public trust? The fact that we have a Clean Air Act?
So the question is, does the Clean Air Act, the federal law that deals with air quality, say that there's a public trust? The Clean Air Act doesn't talk about public trust. The Clean Air Act was interpreted by the Obama administration to put limits on carbon, but of course the Trump administration is rolling that back. So the Clean Air Act is broad enough to regulate carbon, but it's not through a public trust type approach. It just uses a different mechanism.
Look. Yep.
Okay, question here?
The Romans likely were protecting what they could see and likely didn't have much understanding of groundwater or interactions, inundation or saturation. Mm-hmm. And White Bear Lake all of that was involved, right? It's groundwater withdrawal affecting that. So did the public trust doctrine in Minnesota address protections for those groundwater? Did they have to rely on MIRA to do that?
Okay, so that's a very good question because that was a big issue in the case. So there isn't any case law in Minnesota and even in a lot of states that would say that groundwater is a protected resource. It's submerged lands under navigable water. So we're talking about surface waters. So the question is, can you use the public trust doctrine if what is happening is withdrawals of groundwater, but the impact is clearly on a public trust resource. So that was an argument that the defendants made back in California in the Mono Lake case, because these were non-navigable streams, and the court very clearly said, yes, but we are protecting Mono Lake, which is impacted by these non-navigable streams. And the same issue came up in White Bear Lake. The DNR's argument is, you're trying to say that groundwater is protected by the public trust doctrine, and it's not in Minnesota. And the plaintiff's position is, no, we are trying to protect the lake, and so we need to stop the withdrawal of groundwater because of its impact on a protected resource, and the district court agreed with that. And that issue, there was no questions about it in the Court of Appeals argument. There was still some argument in in the briefs. But most courts that have looked at the issue is if you have an impacted resource that is a public trust resource, even if the vehicle that's harming it is groundwater, you can bring that claim. And then there's a few states that have specifically found that groundwater itself is protected by the public trust doctrine. I think Vermont, the courts came to that conclusion, and then the legislature actually codified it. And I think there's a few other states, but that's a very live issue around the country because, of course, a lot of our impacted and threatened resources these days are groundwater in a lot of states.
To extend that real quick, Chapter 7050 of the State Water Quality Standards does include groundwater as a resource, generally narrative, except Class 1, which is drinking water. But it is included in that, but that doesn't extend in the way you're thinking?
Right. So, I mean, the DNR and the state legislature, well, the state legislature and then through the DNR, they can protect whatever resources they want. And certainly the legislature has authorized the DNR to protect groundwater resources. Where the public trust doctrine comes in is when someone wants to argue you, the DNR, are not doing a good enough job of protecting surface waters or groundwaters, or these laws aren't protective enough. So that's where you use things like the public trust doctrine is when, and this is what Joe Sachs envisioned, is that the idea is what the legislature is doing or the regulators are doing is not protective enough. And so the idea is that you can use this public trust doctrine to force them to do more than they're doing under their statute or regulations or even authorized to do under their statutes or regulations. And so the Mono Lake case was a good example of that. David?
Well, thank you very much for a very illuminating discussion. Has there been any attempt to extend public trust doctrine to things such as soil or, let's say, biodiversity, saying that the species and so on are held in public trust? And if so, has any of that been successful in any of the states?
In California, yes. So there are definitely cases out of California where they have found it started with sort of water-based wildlife, particularly birds, migratory birds are protected. And then there's even a California Court of Appeals decision from the 1990s that addressed wind turbines and birds. So in California, birds and other animals are protected resources. And then there's a whole line of case law aside from public trust cases about just states having have a trust relationship with wildlife. That's true here in Minnesota as well. But that's a type of a trust relationship that the legislature really has control over. There's a few other states that have extended it to wildlife. I think New York has an old decision that involves involves parkland, New York State. But most states limit it to resources connected to water, so submerged lands, the water itself, beaches, perhaps wildlife that are, using water-based resources. So there's a few states. Robin Craig, who's a law professor at University of Utah, has a very nice compilation. She has a few articles that basically look at the public trust doctrine and the scope of it in every state in the country. So she has one article on eastern states and another article on western states. So if you want to look and see which states have broader or narrower public trust doctrines and what they cover, that's a good resource. And it's not necessarily the states that you would think. Louisiana has a very expansive public trust doctrine. Hawaii does. That's maybe not that surprising. California. So it's not necessarily the states that you would guess. Question over here. A couple over there.
Thinking about submerged lands, my wife and I live up on Iron Range, and we've had a lot of mining where the old mine pits are abandoned. They fill with water, and I think under certain circumstances, they have become waters of the state. Then I see the Canastillo pit, it flooded, the mining company took interest, so they closed off public access, went back to the mining company. Anyhow, there's submerged lands. Is there a public trust issue once that pit becomes open to the public for fishing? Or is that something where it's always going to go back to mining is a higher priority than surface rights or whatever?
It's not really an issue of priority, at least with regard to the public trust doctrine. It might be under state statutory law, but typically what they look at for public trust resources is, was it submerged land, was it under navigable waters at the time of statehood? So at the time of statehood makes a big difference. And actually the DNR had argued in the White Bear Lake case that White Bear Lake was not navigable at the time of statehood. This was at the summary judgment stage. It was kind of an odd argument because there actually was a lot of data and evidence showing that there were like boats and hotels on the lake and people used it, for recreational purposes. So they gave up on that argument after a little while. But so if it's something newer like that it was not submerged lands at the time Minnesota became a state, the public trust doctrine probably is not that helpful. Doesn't mean that there isn't some protection in existing state, water law or regulations, but you might need the DNR's help on it, with regard to that.
As far as air quality, that can also have a big impact on water quality, like mercury and so forth.
Mm-hmm.
So wouldn't that qualify under public trust?
Well, one of the arguments that at least has been successful in the Oregon case is that connection between the atmosphere. So the court there did recognize the atmosphere as a public trust resource, but part of how it got there was connecting it to the impact of climate change on water resources. So you're right to bring that connection in. Again, here in Minnesota, it's just we don't have any case law to act as law to make that connection. This is real. That's why the White Bear Lake case, from a legal perspective, is so fascinating, because so many other states, it was really in the 1970s and 1980s that this case law got developed, and we have so much less law on the public trust doctrine than just about any other state, which is fascinating because in most areas we've got as much or more law on environmental issues as other states, right? We've had the Pollution Control Agency and the DNR for a long time, and for a time the legislature was quite active in creating a lot of the environmental protections that we have today. But that's one avenue that is just underdeveloped in the state of Minnesota.
Back to the question on groundwater, didn't the plaintiffs and actually U.S. Geological Survey argue that surface water and groundwater are in fact a part of the same resource, just one is buried and the other is not?
Oh, absolutely, absolutely. But the plaintiffs in the case were very careful. They didn't need to make a broad argument that groundwater is a protected public trust resource, right? All you need to argue is that White Bear Lake is protected and you have the impact on the groundwater. So it's a less aggressive argument, and as a lawyer, you want to only make as aggressive an argument as you need, right? So there might be a case, certainly might be a case in the future, where the impact is all to groundwater and there's no connected surface water. Then you'd need to make that argument that groundwater and surface water are connected. There's no reason not to apply the public trust doctrine to groundwater, but here the plaintiffs didn't need that argument.
Does the Clean Water Rule have any impact on any of that or not?
With the Federal Clean Water Act?
Yeah, the rule, the rule they're trying to weaken.
The waters of the United States. No, it doesn't really have any impact on either the public trust doctrine or MIRA, because that's an issue of federal law, so it's limiting federal protection for wetlands, and these claims are all under state law, so these are not under federal law at all.
In the 3M case, was either one of those two cited as a reason for that decision?
Were claims brought under either MIRA or the public trust doctrine? There was not a claim under the public trust doctrine, for sure. I don't think there was a MIRA claim. There was a MIRLA claim. Because there's a natural resource protection, the state can sue to protect their own resources under the basically the Minnesota equivalent of CERCLA, the Superfund law. So there's a claim under that. I think there was a trespass claim. I think there was a nuisance claim. Some others as well. But certainly the public trust doctrine was not included. I don't think there was a MIRA claim either. because that was really more of cleanup of existing pollution, right, and the impact on existing natural resources, including water resources, of course.
After I asked you the question about the Canasteo pit, which is, they mined out about a 3-mile long pit, and all of a sudden I had an image of my mind of an old map of that. There's a little lake called Buckeye Lake on the west end of that pit. They had the whole thing mined out. Now that it's flooded, Buckeye Lake is still on the map. So can I sue them for their pit polluting my lake?
Might be too late. Might be too late, but I'm not here giving legal advice, so talk to a lawyer. Anyone else? Oh, one more.
Does the public trust doctrine primarily relate to public access to the water?
Not anymore.
Not
So
anymore.
that's kind of what it was used for before the era of Joe Sachs, right? It was more about sort of access for fishing and navigation and more commercial purposes, right? Because that was water access is really important for people's livelihoods. But now, what we sort of call the modern the modern public trust doctrine is more environmental protection for its own sake and for wildlife and for all of the aesthetic and environmental resource reasons. So it is beyond that. But you're right that historically it was more limited and more focused on access. All right, great questions from everyone.